It's Entertainment Law Update, episode 170 for July of 2024. Hello, everybody. Welcome to Entertainment Law Update from Los Angeles, California. I am Gordon Firemark.
And from the Dallas-Fort Worth Metroplex, I'm Tamara Bennett.
And we are grateful to you for joining us today for this episode. This is our podcast about entertainment law, where each month we pull together a roundup of legal and business news stories in the entertainment arena and share our opinions and commentary and analysis. And as always, Tamara, it is wonderful to see you. How are things in your neck of the woods?
It's great to see you too, Gordon. You know what? Life is going well. Our adult kiddo is home for a few weeks and then back off to his next adventure in Iceland. So I am going to ask a question of our listening and viewing audience. Anybody got a room to rent in Iceland? Because I need one, or my son needs one. So, I'm asking everybody. You never know who has a connection.
I will put it. I have a few friends from Iceland. Maybe I'll put it out there and see what we can come up with here.
Yeah, so he needs a room for a semester. I will mispronounce the capital name, but Reykjavik.
Reykjavik, yeah.
Yeah, Iceland. He's doing a semester abroad while he is finishing his degree abroad. That is one lucky duck.
Yes, no kidding. I envy Brock his travels and the excitement of all that. That's really cool. So.
Yeah, so we're hoping to we will take all travel tips too. Johnny and I may take a week. Yeah, we may take a week in September to go to Iceland just to kind of. Yeah, I'm hopeful we can make that work with our schedule.
Terrific.
So what's new in your world?
Well, the kids are off school, so we've got a house full of people and pets running around, and it's constant chaos around here, but it's a good kind of chaos, the kind that I think parents will miss after the kids are out of the house, as you probably have experienced. And nice hot summer, to put it lightly. My wife and I were talking about just this timeline that we all are in and the ancient curse of may you live in interesting times. Well, these are pretty interesting times. So I guess we're all cursed.
We're living in very interesting times for sure. Mm-hmm. But
well, let's get to
end. It'll all be okay. I promise. Right. It'll all be okay in the end.
There used to be a radio team here in Los Angeles on KABC. What was the name? I think it was Bob and Ken, and they had this phrase they would use: "Egg buck, everything's going to be okay," and that fits. It fits. So, with a shout out to Bob and Ken. Anyway, this episode of Entertainment Law Update is sponsored by JD Supra, a leading platform in professional services, content marketing, helping lawyers to turn their expertise into networking opportunities, media visibility, and, of course, new business. JD Supra publishes and distributes blog posts, articles, podcasts, videos, and other kinds of thought leadership to its hundreds of thousands of subscribers every day. That includes business leaders, in-house counsel, media members, the C-suite, and others who have a need-to-know interest in legal, regulatory, and compliance matters. JD Supra clients not only enjoy wide readership of their thought leadership content, but they're also provided with the data and tools to turn that visibility into marketing and business development success. So you can find out more about JD Supra by going to resources.jdsupra.com. And we thank them for their support. So,
thank you very much.
Did you experience any issues with your computers and computer systems because of this CrowdStrike problem that happened earlier this week?
I did not. Mm-hmm. I was very thankful I did not. I was also very thankful I was traveling on Thursday and there was weather and things were kind of all messed up. Mm-hmm. And I ended up getting back to Dallas late Thursday night, 11 p.m. or whatever. And then we woke up to this Friday morning and I was like, oh, I'm so glad I got on an airplane last night. But yeah, no disruption on any of my systems at all. How about you?
Yeah. Well, nothing on I'm a Mac user on my desktop and here around and about. So I didn't encounter Microsoft related stuff, except Friday afternoon, I tried to run a trademark search and and wound up getting a can't load the page kind of an error, and it just nothing was working on that end. So the trademark listserv backs me up on that. There have been some reports of problems accessing the search and filing systems at the USPTO, but at the time of this recording, we're recording on Wednesday, the 24th of July. There is no official statement from the USPTO confirming anything, whether it came from CrowdStrike or just something else. And I haven't gone back in and tried. I sort of thought I'd wait until everything seems to shake out.
I did some searches yesterday, and it seemed fine, other than the fact that I still hate the new system. I appreciate they've added the expert search level, so you can go in and put in the search codes as we once knew and loved them. And I haven't, just in this time period, haven't done anything at the U.S. Copyright Office. So I didn't see anything specifically posted, but their system is so wonky anyway. Who would know if CrowdStrike would have affected the registration system at the U.S. Copyright Office?
Yeah, not to put down the text too much, but sometimes, the joke about a trained monkey could do it, and maybe this is what we get when we use trained monkeys to build and run government-run websites or something. But anyway, people have their problems with it. But
that's right. I haven't personally been impacted. But speaking of Iceland, I had good friends flying to Iceland, and that finally worked. Yeah. So I'm again glad we weren't traveling.
I have heard anecdotally that other law firms have had some problems, bigger firms with large, networks built in and things like that. The people working from home couldn't access files on servers and things like that. But it doesn't seem to be affecting people's work in the law field too much. So anyway.
Yeah. And I just wonder, there's all this talk on the news regarding, will this be exploited as a weakness? Is there something we need to be further thinking about or looking at?
Well, I think we as lawyers do have some ethical obligations to harden our systems against hackers and against these kinds of things. But there will always be problems that, that impair our ability to work at the speed we're used to working at or getting things filed. Actually, the LA Superior Court systems have been down enough that they canceled hearings on Monday and Tuesday this week. So,
and that may have been the case in different locales here in Texas. I know, like when one county, you couldn't go get your driver's license. So all of that was shut down. I'm just going to add about kind of that cybersecurity, just to say, everybody check your malpractice insurance. My carrier adds that on, and now I have that coverage. So
you've got cybersecurity.
I got a cyber
error.
policy, errors and omissions policy. So I just as a little, practice management.
Just another reason to raise your rates, the cynical part of me says.
Well, if anybody's in Texas, I'll let you know who I use, because I've been very happy with them for 23 years.
Great. Yeah. Well, and as long as we're mentioning it, maybe now's a good time to change your passwords just to update things and be secure.
That's right. And that was 2 weeks ago that a lot of passwords were released mid 1st of July, baby.
Yep.
A lot of passwords were released on the black web, and that's also a good reminder.
All right. Well, let's get into our legal news stories. The first one we have on our list is about football. The jury in a case has ruled that the NFL owes about $4 billion in an antitrust case. The case is National Football League's Sunday ticket antitrust litigation. And the league has been ordered to pay $96 million to bars that said they were overcharged for the commercial class license to show the Sunday ticket, plus $4.7 billion to fans who paid for the residential class of streaming package for the Sunday ticket show. Under federal antitrust laws, those damages get tripled. So that brings the total to $14.39 billion. That came from an 8-person jury here in Los Angeles District Court after about a decade of processing in the various courts and so on. The case was initially filed in 2015 by a sports bar in San Francisco, the Mucky Duck. I love that name, which claimed that the league violated antitrust law by bundling all of the out-of-market games and making it impossible to buy a package specific to one team. The case was dismissed in 2017, reinstated in 2019, and now is a class action suit made up of millions of bars, restaurants, and subscribers since June of 2011 through February of 2023. So plaintiffs had initially sought about $7 billion in damages. So I guess at 14 something, the NFL, I won't call it a win, but they came out better than they could have if the plaintiffs had their way. So the key claims in the suit were, well, as I've described, by offering Sunday Ticket only via satellite. On YouTube TV, the package for Sunday Ticket cost $349 a year. And the league declined an ESPN proposal to take that over and price it at $70 and include those single team packages and so on. The league had apparently drafted a proposal in 2017 to completely cut the Sunday Ticket licensing entirely, move games to a different number of different cable channels that would air Sunday afternoon out-of-market games that aren't shown on the main network, Fox or CBS. And Roger Goodell, the league, the superintendent of the league, I guess, and then NFL's lawyers, and they've argued that Sunday Ticket is a premium product that wasn't intended to end up in every living room. So the jury ruled that all those decisions by the NFL violated antitrust law, and the NFL says it's going to appeal, and that the suit was baseless and without merit, of course. So we'll see. We'll see what happens with this.
Yeah, okay. So I have a corner on the market. That's what they've got.
Yeah.
And I can't charge what I want to charge for that.
If you and I make a television show or a film and we own the copyright, we own the rights to do it, you'd think that the market would allow us to price it however we want. I guess what the antitrust folks are saying is that by forcing everybody to buy the whole package rather than just the team or the games you want to watch, that's sort of like block booking in the old film parlance, where they would require you to have all of the films coming out of the studio that month, even if you only wanted to show one in your theater. Maybe
and so you can make a profit, you just can't make, and I'm not defending the NFL. Yeah. I mean, I think that's crazy. Mm-hmm. If you in LA only want to watch the Cowboys out of market, you should be able to just watch the Cowboys out of market. And if I want to watch Green Bay here in Dallas or the Rams or whoever, I don't even know what city the Rams are in anymore.
Nor do I.
They're still in California. Are they even in California?
I think they're in St. Louis now. Yeah.
Oh, I think that's right. I think they were in St. Louis. It's time for college football, though. I can tell you that.
Okay.
So, I'm not so big on all my NFL, but anyway.
Anyway,
so it's obviously in the NFL could make money. They could make a profit. Yeah. Nobody's saying they can't make a profit, but you can't be basically forcing this on folks when there are other viable options. Right. When you are the sole controller of this content in the marketplace.
Yes, indeed. So anyway, we'll see if there's appeals, but it was a pretty big verdict and something we thought we should report on. So here we are.
Did they rule on a Thursday, just like Thursday Night Football, which is an oddity, but a new thing?
Maybe. More.
Which you can only watch on Amazon Prime if you want Thursday, or at least last year. So.
Hey, it's big business. Got to have something to offer every day of the week, right? So
that's right.
When is Tuesday morning football going to start happening? Right?
I think that's the football in an hour. You can watch the whole game, or at least, you can watch the whole game in an hour. That's the best way to watch football.
Yeah. Well, it wouldn't be a modern episode of Entertainment Law Update without talking about some of the AI lawsuits that have been going on. And we have a couple of new additions to the long docket of cases involving the AI companies. The first of those that we're going to talk about is UMG and others versus Suno, Inc. This is a couple of different suits filed against Suno and Uncharted Labs, which does business as Udio, by 12 music labels in June, late June this year. Both of the companies involved are generative AI services that allow users to generate digital music files that sound just like original human sound recordings in response to some basic inputs. Seems like pretty cool technology. The process involved copying decades worth of this is the plaintiff's complaint saying this, involved copying decades worth of the world's most popular sound recordings and ingesting those into the AI model so it can generate outputs that imitate the qualities of genuine human musical performance and sound recordings. The complaints actually attack the expected fair use defense in a fairly lengthy analysis, and they point to that there's really no transformative use here because there's no functional purpose for the AI model ingesting these copyrighted recordings other than to spit out new competing music files, and the copying of the sound recordings is for commercial purposes and so on. And on the third factor, the amount and substantiality of the portion used in relation to the copyrighted work as a whole, the complaint said that fair use happens when small amounts are copied and not when the copying is extensive or encompasses the most important parts of the original. And Suno copies at least the most important parts of the thing, and if not the whole thing. So that shouldn't be considered fair use. And basically the allegation is that the ingestion of the recordings is itself the copyright infringement in question. So Udio has responded, and they, right after the complaint was filed, the very next day, they said, the technology is trained by listening to existing recordings and that its AI would never reproduce any of those tracks. And just as students listen to music and study scores, our model has listened to and learned from a large collection of recorded music. And then adds, the goal of model training is to develop an understanding of musical ideas, that is the basic building blocks of musical expression, that are owned by no one. I think that sort of misses the point that the listening involves, I guess it's possible that the technology doesn't have to copy bits of data into a system in order to learn. And there's even the questions about whether copying data into a computer to process it is considered infringement. But it's more than listening that's going on here, I think.
I think so too, but I do feel like we are headed down a path of, is copying alone infringement? Or do we already know the answer to that?
Well, and isn't listening... Yeah, go ahead.
Well, or I just say, do we already know the answer to that? Because, the Google Books cases from 15 years ago, I don't remember how many years ago that was, when they were scanning in all the Google Books, and I don't know. So I
think that's going to be the basis for the defenses here is the Google Books, the Perfect 10 cases, all those that held that those kinds of uses for the betterment of technology were fair use. But I also have to ask, even if it is listening and not duplicating or reproduction, there's a performance right in musical material too. And
so that's interesting.
Is it a public performance is a question, but
I don't think it fits the definition of a public performance, unfortunately, because I don't have the definition in front of me, but go look at the Copyright Act. It's in there. It's outside the scope of your normal family and friends, but is it outside the scope of your normal family and friends if a computer's listening to it? Because it's not human.
Well, that's an interesting point. We talk about that. The scope of the license you get when you buy a piece of music is for personal listening and consumption only. So the question is a computer using it personal? And did they buy it in the first place, or are they making a completely unlicensed use of something? Right?
They're just turning on Spotify and walking
That's
away.
what it is. Yeah. Here, computer, go to sleep and listen to this while you doze. Right? Yeah. Dream of new music.
Dream of new music. So I decided to go do a search and just see what other people had to say about these generative AI products. And as to the audio, I actually watched a little bit of a music producer's video. He was doing a live stream and demonstrating how it works. And I don't understand all of it. Again, I think we've probably discussed this before. I thought I was going to be an audio engineer, but I figured out real quickly that the word engineer was in that. And it's a good thing. So, I switched to doing music business versus the creative part of it.
Right.
And so anyway, I'm watching his, his screen and all the different channels and this and that. And his comment was, I am using this studio as a quote idea farm. Okay. I'm not saying I'm going to copy, and this is now I'm using Tamara's words, that he's going to go in and copy and use what he finds, but he's putting in different characteristics, just like we would if we went to license some music from a stock library. We might put in different characteristics of how we want it to make us feel or how long a certain phrase is. And that's as far as I got, but that's what he was using it for. So I think there might be an argument that there's more to it than, unfortunately, what the plaintiffs have presented as the only purpose.
Yeah, well, it's these are those interesting times we talked about.
Yeah. So we've got a couple of links, but I added a link to the RIAA, and they have, obviously they're all plaintiffs, and they have within that link links to the complaints and just some good information and background in addition to the other links we've added.
Yeah. Well, the next one is the Center for Investigative Reporting against Microsoft. This is a nonprofit news organization, the Center for Investigative Reporting, suing the makers of ChatGPT, that's OpenAI, and their business partner Microsoft, over unauthorized use of the center's content on the AI platforms. And in this case, the nonprofit, which puts out Mother Jones and Reveal, they said that OpenAI used its content without permission and without offering any compensation, violating the organization's copyrights on its journalism. And so this is another one that we'll be watching in New York, Manhattan's federal court. Companies are battling a series of other copyright lawsuits. The New York Times, other media outlets, authors, and so on and so forth. And in response to that, or around the same time, an interesting statement came out of a Microsoft executive. I don't know if you heard about this, Tamara, but the guy who is sort of the head of AI at Microsoft, Mustafa Suleyman, made a statement saying that the moment you publish anything on the open web, it becomes freeware that anyone can freely copy and use. Actually, he said he used the phrase fair use, and I think he also called it public domain. Publish it on the web, it's public domain, and therefore anybody can use it as fair use. And
that didn't run through legal before he made that statement, did it?
It didn't.
Because that's kind of not real good for Microsoft.
No, my response, I was interviewed about it a few days later. My response was, great, then I'm going to go download every Microsoft product I can find on the web and call it fair use and use it as I choose.
Hey, so put your link where you were interviewed in the show notes so everybody can go take a listen.
I will do that.
That'd be awesome. Thank you.
Yeah.
Love to hear about that.
It was for Pod News Weekly, which is the podcasting industry thing. So,
and that one, as you said, was in, I'm looking, New York, Manhattan, New York. The other two cases, just in case folks are interested, the EO case was filed in the Southern District, New York, and the Suno case was filed in Massachusetts.
Yep.
So
Massachusetts, that's an interesting. It's not a venue we hear about very often in copyright cases.
It is not, and I didn't dig any deeper to see if that's maybe where
probably where the defendant's based,
where the defendant's corporate office is, maybe, and just to make sure there was no issue with that, they filed there.
Yeah. Well, let's talk about the Parkland shooter and the life rights situation. Did you see this?
I did.
Yeah.
So. Anyway, the tone has to change. I mean, it's awful to imagine. It was 2018, 17 adult and children's killed, murdered, 17, wounded.
Mm-hmm.
And what was it, February 14th, 2018, when Nicholas Cruz opened fire at the high school in Parkland, Florida.
Yeah.
So it's a couple of interesting things that we don't have in our rundown that I kind of went and read about was that a bulk, if not all of, excluding one of the victims and the victims, surviving victims and the victims' families, did kind of a large settlement, group settlement. But this one gentleman, Mr. Borges, did not, and he actually settled with Cruz and his family. And part of that civil settlement was Cruz being the perpetrator, the criminal. One of the victims acquired Cruz's name, image, and likeness, and totally taking the power and control away from Cruz. So it limits, Cruz can't enter into any agreements with documentary filmmakers, interviews, book deals, consent to streaming. He can do nothing without Borges' written permission. So there's probably not going to be any telling of his story from Cruz's direct point of view anytime soon.
So this all got me thinking about the Son of Sam laws from the 70s that basically said that, in that case, David Berkowitz was not allowed to sell his story to the media. And I think it was until 1991 that that law was actually held unconstitutional. So here we have a settlement of a lawsuit trying to sort of do the same thing, restrict the perpetrator's ability to profit from the story of their crime. And I don't know, it's pretty interesting. And those Son of Sam laws have been amended and revised to be more constitutional, but they would still allow for a criminal to to make a contract that allows them to tell their story to a journalist or a filmmaker or something like that, because that's expressive speech and we can't make laws that act as a prior restraint on that. But we can make contracts that act that way. So the settlement agreement becomes that contract. Is that your understanding?
I mean, that's my take on it. I mean, is that any different than signing agreement with someone for any other reason? Well, any activity that you might not want in the limelight, so you purchase their rights for that.
Now, the thing about life rights is that there is really no such thing as life rights. It's a package of promises not to cooperate with anybody else and to cooperate with the filmmaker and those kinds of things. So what Cruz has given to Borges and his family is the promise not to allow anybody else to interview him and not to cooperate with any other production and not to sue for defamation and those kinds of things. But the facts of the story are still public domain information. And so
that's right.
Limited impact as a practical matter, I think. If somebody wants to tell the story of the Parkland shooter, they can still do so. They just can't get Nicholas Cruz to be interviewed or participate in that.
Right. Yeah. And that story, if not told already, will be told, because there's going to be enough facts and news information available, as well as interviewing of many other people to tell the story. Well, I wonder if we will continue to see a trend in this situation of this happening. Unfortunately, it sounds like there were some disputes amongst the families and the victims as far as how things were going to settle. Because I was like, the reason I went and dug a little deeper was it was like, well, how did this vest in one person as opposed to the next story we're going to talk about and some documentation. So, yeah, I think it's interesting. And I haven't gone and looked at the Son of Sam laws in forever.
Yeah.
Even as a non-lawyer, I feel like it was such a part of our culture that I was very aware of it at the time. So, yeah. But the next one hits kind of close to home for me because it happened in Nashville, where I grew up in that area, and I wasn't there when it happened, but I've kind of been there a little bit as these conversations have been happening. The Nashville, it was private Covenant school. It was a shooter. The writings of the person who killed 3 9-year-olds and 3 adults at the Christian elementary school in Nashville last year, those writings cannot be released to the public because the victims' families, a collective of people, own the copyright to the documents. The shooter's family granted those rights. The shooter's parents granted those rights to the victims. The shooter, Audrey Hale, left behind at least 20 journals, a suicide note, and a memoir, according to the court filings. And public speculation about the shooter rose quickly after the March 27, 2023 shooting. Part of the interest in the records stemmed from the fact who police say that the shooter was assigned female at birth, may have identified as a transgender male. A transgender man, and some pundits have floated the theory that the shooter's writings would reveal a planned hate crime against Christians. This was a private Christian school. And there's been freedom of information filings to see the documents seized by the Davidson County Metro Nashville Police as part of their investigation. I can understand why there are reasons the police want to keep those documents, control over them as they do their investigation.
The police are claiming that there's an ongoing investigation, but in this case, the proposed defendant in any kind of a case, I think, is the deceased shooter. Now, maybe they're investigating the family and looking for other hooks to hang hats on, but it doesn't seem like it's really an ongoing investigation if your suspect is dead. You're not going to charge a dead person with the crime, right? So that's one part of the trouble. The judge in the case, and Tennessee still has chancery courts, equity courts, and law courts that are separate. So the judge is referred to as a chancellor, not a judge, but Chancellor Miles in this case, she says that copyright law, because it's federal, preempts and then acts essentially as an exception to the Tennessee Public Records Act, and agreed with the parents group, finding that the original writings and things like that amount to this exception that copyright is superseding a state Freedom of Information Act requirement. There's a federal Freedom of Information Act also. So I don't know. I wonder if this is going to stand up.
Because I think two things can coexist at one time. Yeah. These works at the moment of creation are protected by copyright if they are original.
Yeah.
And independently created, so for purposes of our conversation, I'm going to assume that a copyright arose in all of these writings. And they would have passed under the Copyright Act to the parents because there was she, to my knowledge, had no child. And so I think the parents can do whatever they want to with the copyright. They can assign the copyright in those works.
Yeah.
And then the question becomes, but as whoever owns the copyright, can they keep all of that out of the public eye? Not saying it would be put into the public domain, because I don't think that's the goal that folks are wanting to do. But they, as the owner, can limit the publication
of the content of those writings, but not the ideas, the facts, the nature of the tone of what he was writing and they were writing, and all of that a journalist can glean a lot of information without ever reproducing the expression that's on the page.
So you're thinking
that access to the information is not the same as copying or performance or reproduction.
That perhaps it may not be access as in, hey, everybody come download, or we're putting this in a Dropbox, come access it. But maybe there could be, just like there, where trust or estates have put certain writings that are unpublished to be held. that maybe they can be viewed for academic purposes, but they have to be held and can't be published for the general public for X number of years. So maybe there's something along that line from a journalistic oversight.
Yeah, it's sort of the difference between,
review.
Hey, let me look at this stuff to see if we can figure out what was going on with this person. What was their motivation, without necessarily having to quote even a sentence from those documents. You could still say he had a beef against the system, or his relationship with his parents was fraught, or whatever, those kinds of things. I keep saying his. I forgive my political incorrectness.
That's okay.
So
Miss Audrey is not available to let us know how she would they would prefer us to refer.
Well, and there was another thing, apparently, a couple of wrinkles in here that are interesting. One is, apparently, at least in some of the writings, there was a statement of, please read my will. So that calls into question of whether this person died intestate or not, and whether the person's parents, family, actually own the copyright in this material. It seems like they would have to be a reasonably astute thinker to have addressed that and maneuvered in that way, but anything could happen, right? So maybe the family didn't really have the right to convey the copyright. Who knows?
Who knows? I mean, it's just, I don't want to lose sight of the victims and their families as we discuss kind of the legal minutia.
But to me, the fact
how it could work.
Yeah, but the fact is, the media is going to still talk about this stuff. That protecting the victims, yes, there's a concern there, but instead of talking about what his writings said and contained, now we're talking about the fact that he had these writings that nobody is allowed to see, and almost demonizing the victims a little bit for putting the journalists in this position. And it's sort of a Streisand effect. You're talking about the fact of the dispute rather than the fact of what was in the letter, the materials. The interesting or the troubling thing for me is that here we have the journalists who received some leaks and posted them on social media. Anyway, the Tennessee Star published a bunch of stories based on apparently some of these writings that were provided to them by an unnamed source. And the plaintiffs in this lawsuit now are addressing it because apparently this chancellor threatened to hold the paper's editor-in-chief and owner in contempt of court for publishing news. The police claim the writings are part of this ongoing investigation, and the judge ordered Patrick Leahy, the editor-in-chief, to explain why he shouldn't be held in contempt for the publication. So threatening journalists with jail time for publishing truthful information. That is as un-American as it gets, if you ask me.
Right. That's a violation.
Yeah.
I mean, that's...
So my expectation is there will be appeals and writs and all kinds of good stuff happening, and we'll be talking more about this down the line.
But I do, as we talk through this, I mean, I think a potential solution would be having these papers stored in an archival setting at an institution with who knows how to deal with those kinds of things. That limits that access, that limits removal, Yeah.
Well, there's even a question of whether or not these papers, these writings of the perpetrator are actually public records. They happen to be in the custody of the police who have been running an investigation. But the police didn't create these things. They were created by this person. And I mean, I guess that could be another argument against releasing it is, wait, we can't release information that is proprietary just because it's held in the custody of a government agency.
Yeah.
But again, government agencies are subject to these freedom of information requests. So I don't know. This could be an interesting strategy in protecting one's written material. Well, my tax return or some other information I might have about my I don't know, the relationship, or I wrote an essay to the court in the form of a declaration. Yes, it's a public record, but I'm the owner of the copyright in the content. Now it's no longer available to be reproduced if it's newsworthy content. I don't know. Then we get into fair use. Does this restriction prohibit the publications from doing fair use of the material? So I think this is really a fraught situation, as you can probably tell by my tone.
Well, it is, because let's take it out of this scenario and put it into a dozen different scenarios that are happening around the world of documents that have been put into a police investigation that we want to see.
What if the family of the would-be assassin of Donald Trump from a couple of weeks ago wanted to prevent the writings from coming out? Could they? I guess so.
They? I mean, yeah. I mean, that's...
Yeah. Interesting.
Interesting times. Interesting times.
Indeed. Well, but let's move on to our next story, which is, a little less of a hot button issue, I guess you could say. Although guitar players are going to have their thoughts on this. Gibson guitars have been involved in a trademark dispute for quite a long while now. And in this instance, the case is Gibson Inc. versus Armadillo Distribution Enterprises Incorporated and Concordia Investment Partners, LLC. Disputes over the shapes of guitar bodies, the largest part of the guitar, and the headstocks, where the tension rods are adjusted to tune the thing. Gibson, company that started in the 1800s, produced its first electric guitar in 1940s somewhere. The guitar had a solid body and a dove wing shaped headstock. Gibson expanded in the latter half of the 20th century, particularly with the introduction of the Flying V and the Z-shaped Explorer guitars in the 1950s. And they started doing semi-hollow guitar bodies, the ES335 model, and introduced the SG model in 1960. So they applied for a trademark and received a registration for various of these body shapes, the dove wing headstock, the hummingbird wordmark. And over time, Dean brand guitars emerged as a major competitor. Dean was founded in 1976 by Dean Zielinski and gained popularity in the 80s with models like the Dean V and the Dean Z. They were used by a number of notable rock bands. And in 1991, Zielinski sold that business. And 1995, Armadillo had acquired the Dean brand, continuing to produce the Dean V, the Dean Z, and so on. Armadillo later introduced the Luna Athena acoustic guitar, resembling the Gibson ES335 and the Hummingbird acoustic. And in 2013, they released a Grand Sport model similar to the SG. So, back in 2004, Concordia, which is a holding company involved with Armadillo, sought to trademark a winged headstock design. Gibson opposed and claimed confusion with its dove wing headstock, and they agreed at the time in 2004 to resolve the dispute, but it continued lingering until 2009. The TTAB denied the application, and in 2015, Gibson came back to the issue. There was some negotiations that had gone on and failed, and then was a bankruptcy reorganization. And ultimately, in 2019, Gibson filed its suit against Armadillo and Concordia. So in May of that year, Gibson sued for trademark infringement, counterfeiting, and other claims under the Lanham Act and under Texas law, and sought damages and injunction. And Armadillo moved for a summary judgment, but the court found that there were material factual disputes. So before the trial, a bunch of evidentiary motions and Gibson's motion to exclude evidence of third-party guitar use prior to 1992, saying that it didn't have much probative value. Armadillo opposed, saying, no, it's relevant to whether Gibson's marks are generic. And the court granted the motion limiting that evidence. So that's what's going on in this appeal. During that trial, and now in 2022, the Armadillo made a motion for judgment as a matter of law. That was denied. The jury found that Armadillo infringed most of Gibson's trademarks and counterfeited certain shapes, awarded $4,000 in statutory damages and no actual damages. And the court
That
issued,
stings.
yeah, right. The court issued a permanent injunction against Armadillo, and a bunch of post-trial relief motions and a new trial were denied, and that's why we have this appeal. So it's all mostly centered around this exclusion of evidence of third-party use of these designs for decades. And that was really central to the dispute. Armadillo argued that the evidence was critical for its defense of genericness and a counterclaim seeking cancellation of Gibson's trademarks. The court had to decide whether the district court had abused its discretion. So, this third-party evidence shows how other parties have used the alleged mark, and it is relevant to whether or not it's become generic, I guess you could say. So,
yeah, and so it's not that they excluded all third-party evidence, it's just evidence predating 1992. And I'm not sure why that was the cutoff. There had to have been some reason that was.
Wasn't that when some of the trademarks were granted? When
or a different product line came out.
Yeah.
But
okay. So,
but the court found that if excluding the third-party evidence based solely on age was incorrect.
Yeah.
So I guess we can look back for a long, long time now on.
Hey, if it's become generic, it's become generic. It's sort of not relevant when that happened. Whether it happened 50 years ago or 5 years ago.
I guess so. I
think that's the argument.
Think of a case. Yeah. Right, because once it's generic, I don't think you can pull it back from the edge before it falls over the generic edge.
Right.
But once it goes over, I don't think there's any getting it back.
I can't imagine how you do that. Well, anyway, so the court said that the decision to exclude the evidence was in error, and it was not a harmless error. The evidence was crucial to the genericness defense. That's a core issue because generic marks can't be protected under trademark law. And so the wholesale exclusion of this evidence meant the jury didn't have a complete picture and hampered the defense. So a new trial gets ordered, and the court emphasized that Rule 403 of the Federal Rules of Evidence shouldn't be used to broadly exclude relevant evidence that's crucial to a party's primary defense. So reversed, remanded, new trial, and we'll see.
Yeah, and I think it's probably a good. There's going to be a lot of good information there if you're looking at a generic.
Yeah.
On a trademark as to what really happens.
Yeah.
I mean, I think there's a lot in the weeds to dig out from a trademark practice standpoint.
So all of this over a $4,000 damages award.
But it's an iconic Gibson guitar.
Yeah, of course. I mean, the injunction is really the value in that ruling or in the verdict. But if you're either of these parties, doesn't this sort of say maybe we ought to just figure out a settlement and be done with each other, or should we spend another $1 million on legal?
I think it definitely says we should work this out amongst ourselves because does Gibson want a pronouncement of genericism? No,
of course not. Yeah. I don't know. I mean, is this what you would consider? People use the phrase "bet the company" litigation. $4,000 isn't bet the company, but the injunction could be, and a genericness finding really could be also, because now if it's generic, then you get thousands of knockoff Gibson designs, arguably.
Right, and then I guess it goes to if we had 10 guitar players lined up to interview,
right?
They would be like, I don't care what it looks like. It's not a Gibson, or it's never going to sound the same as a Gibson, or it's never going to sound the same as a Dean.
Right.
So, will consumers, I think the concern is this is maybe not targeted to the savvy professional musician who's playing and selecting guitar. It's the average person who's buying a guitar, and that consumer could be confused.
Yeah.
If the designs are similar.
Yes, indeed.
Anyway.
Yes, indeed. Well, we have some interesting news coming out of the Copyright Office. A couple of final rule-making decisions have made their way into into the space. First off is the final rule regarding termination rights. Why don't you take this one? It's a music story.
Yeah, so the U.S. Copyright Office issued its final ruling in the proceeding, big name here, termination rights, royalty distributions, ownership transfers, disputes, and the Music Modernization Act. So music publishers and songwriters have been waiting for this to happen. So in this final rule confirms that the derivative works exception to termination rights under the Copyright Act does not apply to statutory mechanical blanket licensing established by the Music Modernization Act. So the rule directs the Mechanical Licensing Collective, the MLC, to make future royalty distributions in a manner consistent with this understanding of this exception, and to engage in corrective royalty adjustment processes to correct earlier overpayments that were based on the erroneous understanding of this exception. And it addresses timing and notices for making these payments. So we've talked about many times the right under the Copyright Act to terminate certain copyright grants, including transfers of licenses. The Act provides that the termination is subject to an exception, which allows derivative works prepared under the authority of a grant before the termination to continue to be utilized under that existing grant. So, a book is published, it's out there, or there's a derivative, there's a film made from a book. It doesn't mean that the film, once the rights are terminated to the copyright grant for the book, that this derivative film suddenly has to be taken away, or that there's no money or revenue made from that.
Yeah.
So what's happened, a cover recording. So we have a cover recording of a song for which the U.S. copyright grant the termination has been triggered, and again, I'm just picking a record label here. Sony continues to distribute the physical CD in the US. They can collect that money. That fits under the ability to create a derivative work and to continue to collect the money. But the new exception is saying, but Sony, if you have that exact same sound, or not the sound recording could be playing, which then triggers the underlying publishing payment. That money is going to go to the songwriter or the heirs that affected the termination. It is not going to be payable to the music publisher.
Yeah.
So there's still a dispute policy. Do I see this being a complete and total resolution? No, I think with anything, there's always this issue of how is it going to get marked? How is it going to get routed? Well, just the back end technology and the fact that there are human beings involved as well to redirect those funds to the proper party.
Yeah. And it seems like the logical outcome. I guess, there were those with vested interests in licenses that had been issued, and then, these terminations happen. I see why there was a need for this rulemaking, but it does come out the way I think most folks expected this to be the outcome. Yeah.
I don't know if they did or not, to be honest with you. I mean, so it's taking money that would have been, say, going to XYZ publishing company. Now the heirs have terminated that grant, and either the money would then be directed for these pre-existing derivative works would either be directed to the heir, or most likely the heir signed a deal with QPW or whatever publishing company. So I think it's going to be an accounting nightmare. But I think the problem it was an accounting nightmare. And this hopefully will resolve it.
At least now we have some guidelines with which to use to figure it out. Without argument, without further dispute and argument. I don't know. Does this rulemaking, is it subject to some appeals or anything like that? Do you think that goes that way, or?
I don't No.
I mean, I guess there could be
If
some
the
administrative
copyright,
law.
or if the Copyright Royalty Tribunal maybe has the ability, the CRT has the ability to review.
Yeah, we
Or
may
not.
find
I mean,
out.
it went through the process for comments, and I'm sure it went through all of the proper process, but we'll see.
Yeah.
Well, and I'll keep you posted as I see various things that come across my desk where payees make comments about it. And if there's anything I can share as to how it's actually working, I will do it.
Groovy. Well, another final rule came out of the Copyright Office just about a week ago now. Actually, just a few days ago. This is about group registration for updates to news websites, GRNW it's called. And this allows news publishers to register frequently updated news websites as collective works with a deposit composed of identifying material showing sufficient portions of the works included rather than complete contents of the website. So this is addressing the rapid pace that web-based materials are created and updated, and how it presents a challenge for copyright owners who want to protect online news works. These publishers have expressed concern that the registration options that were currently available to them are expensive and burdensome, and so after consideration of these benefits to the copyright owners and the impact on the public record, the ability to efficiently examine the works, the Copyright Office has established this rule saying, okay, if you're a news publication, you can submit group registrations from time to time that cover all of your body of work on the site, and so on. And they've got more information. This is something I've been watching pretty carefully because I think it's too narrow, being limited only to online news websites. As somebody who talks to podcasters about their copyrights all the time, if you're putting out a weekly podcast, there's a significant expense in registering the copyright in every episode. So in practice, what happens is people don't register their copyrights, and they want to.
And I haven't read the definition of what a news outlet or whatever and I don't know how they define it. Online news publisher is the defined term. I don't know. Maybe it's broad enough to cover a few more things.
Yeah, but if I do a comedy podcast, it's there's certain. This is one of those things where
that's not going to be
under inclusive and maybe overbroad at the same. Who knows? And so, what I'm hoping is that this opens the door for a move to expand that definition or develop another rule allowing for group registrations for other kinds of works. Right now, I think it exists for unpublished photographs and these news websites, and I think there's one other category that you can do it. A group registration.
A large collective. So you can for unpublished songs and sound recordings, but it's limited in the number.
Yeah.
So it's very limited.
And unpublished works, maybe podcasts are unpublished sound recordings, because I know the definition of publication is a little maneuverable,
so that would also be the.
Go ahead.
Well, I was going to say that it's the same thing for a news website. If you're not giving me the ability to download that content, it's not published. Well, this is the $1 million question. I think the Copyright Office, issued a whole big paper on that, and we still don't know for sure, but it's not. We
had the question of performance versus publication going back to the I Have a Dream speech case, right?
Yeah.
And merely performing the work or allowing it to stream, is that a public? Yeah, good question. Of course, I think also if it's behind a paywall, like say the New York Times, you can't download the article, but it's behind a paywall, so that is probably publication. So just something to be thinking about if you are working in a space that doesn't have this and you want it. Let's get together and figure out a way to petition the Copyright Office to do something and expand these definitions to include these.
Sure.
So,
well, as I say, once again, we have had a ruling that says your exercise movements and routines probably just don't rise to copyright. What do you think? Exercise routines and copyright. Fitness company sues a former instructor. This is Tracy Anderson.
Yeah.
Mind and Body LLC versus Megan Roop et al.
So she's
Tracy
a trainer.
Anderson was Tracy Anderson was the founder and CEO of her company and a particular exercise method, the TA method, combining choreography, fitness, cardiovascular movements. I'm just going to summarize here.
Yeah.
Dance fitness.
Yep.
And her company owns the copyright for 19 DVDs based on this method. And I don't think anybody's challenging the copyright in the DVDs in this case, but she had a trainer who worked for her, who it doesn't say that she was an employee, but I'm assuming was an independent contractor, signed an agreement with a confidentiality clause, saying she would not release confidential information, workout routines, client list. But also, I think there was this understanding that the trainer would not go take these specific movements or routines or order of the exercises and use those, which when she left, Ms. Roop emailed potential clients, including this company's clients, about her new dance cardio workout, which she launched in March of 2017. She created her own training manual, allegedly using the confidential information of Tracy Anderson's company. And in July 2022, Tracy Anderson's company sued her for copyright infringement, breach of contract, unfair competition, alleging the videos copied choreography, the new videos, movements, sequences, and routines from the existing TA Works DVDs, and that the copyright in the DVDs extended to the routines that underlie that were demonstrated on the DVD. Here's what's interesting. The defendants did not dispute the similarity between the parties' routines, but argued that TAMB, which is Tracy Anderson, could not prove its claim because the exercises are not copyrightable under the precedent set by Bikram's Yoga College of India versus Evolution Yoga, which we talked about multiple times over the years, and that exercises are not protectable choreography. There was also some issue about some copyright ownership, but I think the key point is these routines fall into a method and protocol which are fundamentally unprotectable methods or systems of exercise, just like a sequence in yoga. They're fitness, and they're designed for fitness and health benefits versus artistic expression. So, there was no claim of identically copying the DVD and trying to pass them off as hers. She came up with routines, or maybe she copied the identical routines, but there's no copyright infringement. But on the breach of contract claim, maybe there was. Under California law, the breach of contract claims, there must be an existence of a contract, performance by the plaintiff, breach by the defendant, and damages. And the court focused on the fact that they do believe that confidential client information, training manuals, and such were taken. The court said with the evidence that there was a genuine dispute of fact regarding the breach of contract claim, and that precluded a summary judgment. So summary judgment denied on the breach of contract claim, but granted as to the copyright claim. So once again, we've got more case law telling us that a system of exercise or an exercise routine does not rise to the same level as choreography.
Yeah.
What do you think?
Well, non-expressive. I mean, do you have to be telling a story for it to be expressive? I get it. I mean, if you follow the logic of the plaintiffs here, you would be able to say, well, if I do three bicep curls in a row, that's a routine that is choreography. And I'm simplifying it.
We would never be able to go to yoga class and do a grapevine again.
Exactly.
I mean,
what's a grapevine? But anyway.
Yeah, I'm not demonstrating. It's been if anybody's listening and they're like, oh, it's been a while since she's been to a dance. Now that it's dance fitness, it wasn't dance fitness the last time I went. It was a long time ago.
Yeah. One other little note here. There was also an affirmative defense brought by the defendant that argued that the confidentiality covenant in this contract relationship was actually a restraint of trade in violation of a California code, Business and Professions Code 16600. And this is an argument that I've seen made a bit, that you can't require, basically saying that a confidentiality clause is tantamount to a non-compete clause. And the court's saying I wasn't buying that, not giving that a summary judgment finding anyway. So that may be open for further discussion as well. So it'd be interesting to see.
And yeah, because you're right. Because I see that clause popping up in a lot of times in contracts, and I'm going, we're not even in California, people. And maybe it doesn't matter so much now that the ruling is that we can't. The restriction on non-competes has changed that we talked about several episodes ago.
Yep.
But thank you. I skipped right over that.
Yeah. We've got a few sort of very quick takes to cover here real quickly, things that we've talked about in the past that have reached some kind of a resolution. We'll start with Nirvana and Mark Jacobs. This case is something we've been talking about for 5 years, 6 years now. Episode 115 back in 2019, we gave a follow-up from the initial beginning of the case. Nirvana's lawyers had sued Mark Jacobs. I think it was backwards. I think it was Mark Jacobs sued Nirvana over the use of the logo on the cover with the smiley face with the squiggly smile, I think.
Squiggly.
The yellow smiley face with X'd out eyes was used on a t-shirt design. Oh, no, it was a t-shirt design. The Nirvana design was used on a Mark Jacobs t-shirt. The parties have now settled. The 6-year legal dispute ended in a 3-way settlement involving Nirvana and Robert Fisher, an art director from Geffen Records at the time, who said that he created the logo, and of course Mark Jacobs. So the terms of the deal aren't disclosed, but case is over. Well done.
There you go. And I have to tell you, I got the news about this Rust case being dismissed against Alec Baldwin actually through our feed.
Yeah.
Of what we put together for our stories before I even saw it on the news. So the manslaughter case against Alec Baldwin has been dismissed with prejudice after the court found undisclosed evidence. Quote, the state is highly culpable for its failure to provide discovery to the defendant. Judge Marlo Sommer said, if this conduct does not rise to the level of bad faith, it certainly comes so near to bad faith as to show signs of scorching. Closed quote. So, yeah, I was a little confused. How did these bullets not show up in the evidence? But the bullets were being used as evidence in the trial of Hannah Gutierrez Reed, the film's armorer, who was convicted of involuntary manslaughter in March in this same process. The investigator for Baldwin's case, upon receiving the bullets, wrote a report, logged the evidence, and did not give it to the defense.
Pretty clear.
Obviously, the defense is arguing they were deliberately hid. In this case, the court said that the prosecutors violated the Brady rule. I hadn't thought about that in a while in my legal world, which holds that prosecutors cannot hide important exculpatory evidence from the defense because that violates the fundamental protection of a fair trial, whether it's intentional or not. Although this type of violation is not entirely uncommon, this is just kind of our commentary.
Yeah.
Through the database of 5 years worth of discovery claims, law professors found these kinds of violations in 10% of cases where the claims were raised. And I guess kind of my additional reading was a lot of times these claims are not raised real time in the middle of the trial. It's years and years later after a conviction has occurred and it's being reviewed. And so the criminal suit is done, correct? With prejudice. There will be no more criminal action against Alec Baldwin. That's how I read that.
Yeah, there's still a civil case moving forward where the Hutchins widower, he settled the case, in October of 2022, but the production still has not made the payments that were called for. So something still going on there. So they may restart some civil proceedings or something like that. So anyway, Well, that's going to be it for. I'm sorry, go ahead.
Oh, no, go right ahead.
Well, that brings us to the end of this episode of Entertainment Law Update. Thank you very much to you, the listener, for spending your time with us, and to our sponsor, JD Supra, that leading platform in professional services content marketing that helps lawyers turn their expertise into networking opportunities, media visibility, and new business. You can find out more information about JD Supra at resources.jdsupra.com. And if you have any feedback for us, we welcome it. You can leave it for us by using the little voice widget on the right side of our website over at entertainmentlawupdate.com, or send us email at entertainmentlawupdate@gmail.com, or on the site formerly known as Twitter, now X. It's at entlawupdate. And Tamara, how can listeners reach you?
Yeah, you can find me online, most social media at Tamara Bennett, tbennettlaw.com or createprotect.com will take you to my website.
All right. And from Los Angeles, I'm Gordon Firemark. My website is at firemark.com with email address gfiremark@firemark.com. And gfiremark is my handle on most social media websites. You can reach me that way as well. I want to say thank you to our team of volunteer contributors. Managing editor is John Janicek. We also had Charles Thorne and Alexis Allen, Violet Zhang, and Tasha Spear and Dawson Holder all contributed to this episode. So if you are interested in joining the fun and becoming a part of our little family of contributors, reach out to us at entertainmentlawupdate@gmail.com. And that's going to do it. That's going to wrap up our current episode. And we'll see you again next time. Thanks again for listening. And until next time, that's showbiz.